Wednesday morning, Viktor Sarn, most famous property tycoon, one-time deputy premier, woke up to find 200 million crowns of his company's money gone dark, not stolen, not seized in trucks, frozen by a single signature through banking machinery most citizens have never heard of. The court papers landed yesterday. I've read all 62 pages. Here's what the headlines got wrong. Because this story isn't about whether Sarn pays. It's about how you actually immobilize the money of a man whose empire is deliberately built to be unimmobilizable. 30 seconds of context. Viktor Sarn built Sarn Holdings from one riverfront warehouse into 40-plus companies, hotels, towers, marinas spread across 3 provinces. Served 18 months as deputy premier before returning to business. In February, the commercial court hit him with a 510 million crown civil fraud penalty for inflating property valuations to win cheaper credit. He appealed. He posted the reduced surety of 190 million in April. Everyone thought the fight would go quiet for a year while the appeal crawled forward. Everyone was wrong. Last week, Public Advocate Mira Castellan, Ardina's chief civil enforcement officer, filed new motions. Yesterday, Justice Halloran granted them. And the way she executed it is the actual story. Timeline, fast version. February, judgment lands. March through May, appeal filed. Sarn's lawyers argue the full surety is impossible to post. Early June, appellate panel cuts the surety. Sarn complies. Last Tuesday, the advocate's office moves to secure assets beyond the surety. Yesterday, 9:52 a.m., emergency turnover order signed. By 11:05 a.m., 3 banks had locked accounts. 73 minutes, start to finish. Now the documents. First filing, page 6. Direct quote, pursuant to expedited turnover proceedings under Commercial Procedure Article 88, the court directs immobilization of funds held in accounts terminating 3,308, 7,141, and 5,526. Not my interpretation. The filing's words. 3 accounts. Then page 13 names the institutions. Ardina Mercantile Bank, Coastal Union, and the successor accounts of the collapsed Halberd Bank, now administered through Northgate Financial. 3 separate banks, same morning, each account tied to a different Sarn Holdings subsidiary, each freeze executed within 41 minutes of the others. How is that speed even possible? Page 22. The filing invokes something called a Rapid Settlement Directive, RSD-9, a mechanism inside the central bank of Ardina's ClearNet payment rails. Here's the part almost nobody covered. Under ordinary collection, a judgment creditor chases accounts one bank at a time. Court orders, service of process, compliance windows, months. But when a judgment exceeds 100 million crowns, Ardinian law lets the creditor petition for direct central bank notification. Every member bank gets flagged simultaneously through ClearNet. Compliance window, 4 hours, not optional. I dug through the enforcement registry. RSD-9 has been triggered exactly 9 times since it was written into law after the Halberd collapse. 9. This is not a routine tool. This is the fire axe behind the glass. That's why 3 banks moved in 41 minutes. They weren't cooperating with the advocate. They were complying with the central bank. The immediate fallout from page 29. Sarn Holdings payroll account restricted. The property management master account restricted. The Bell Harbor Resort operating account restricted before lunch. And here's the detail that told me the advocates team knew exactly what they were doing. Page 33. They didn't just freeze the checking accounts. They froze the overnight ladder accounts. Quick explainer, because this matters. Wealthy operations don't let cash sleep. Money sits in operating accounts during business hours, then automatically ladders into overnight money market positions to earn yield and returns by morning. Freeze only the checking account and the money keeps moving around the block. Freeze the ladder account and the entire circulation stops. The filing lists 6 ladder accounts across 4 institutions. That's the real 200 million. Now, the obvious question. Didn't Sarn already post a 190 million surety? Yes, different money. The surety came from an insurance consortium. These frozen accounts are Sarn Holdings operating capital. What Castellan's office is doing is building a second wall. Securing assets beyond the surety in case the appeal fails and the full 510 million comes due. One more thing before the break. Page 51 lists projected revenues monthly cash flow estimates for every Sarn property under management. They're not just freezing what exists. They're mapping what his empire will earn, preparing to intercept future income. That's not collection. That's a siege plan. That's one filing. There are 3. Subscribe because the next document is where this stops being about one tycoon. All right, fairness time. Because Sarn's side has real arguments, and pretending otherwise would make this propaganda instead of analysis. Argument 1, he complied. The appellate panel set the surety at $190 million. He posted it on time, in full. Piling additional freezes on top of a posted surety while the appeal is still alive starts to look like punishment before the verdict. Argument 2. These aren't Viktor Sarn's personal accounts. They're operating accounts that pay roughly 1,900 employees, hundreds of vendors, dozens of contractors. Freeze the machine and you crush people who were never accused of anything. His lead counsel, Petra Molnar, went further on Tuesday's steps. This is fiscal warfare against a political rival dressed in procedural clothing. Discount the theater, and there's still a kernel. Sarn is openly weighing a return to politics next year. The timing invites the question. And their strongest exhibit is precedent or the absence of it. Molnar's response brief cites 2 prior cases. The Devereaux shipping judgment, 2018, 40 million crowns, surety posted, no freeze during appeal. The Castellan casino judgment, 2021, 65 million, same pattern surety, appeal, no additional seizure, different scale, yes. But the principle those cases stood for was simple. Post the surety and the state stands down until the appeal resolves. Why is Sarn different? His team says politics. The advocate says magnitude, plus a documented history of shuffling assets between subsidiaries when creditors approach. Even commentators with no love for Sarn are uneasy. Broadcast legal analyst Thomas Reiner, who called the original fraud verdict richly deserved, described Tuesday's freeze as the most aggressive post-surety enforcement I've seen in 20 years of covering these courts. So hold both thoughts. The advocate's reading, a defendant with 40 shell-layered companies and a history of asset migration, is precisely who dissipation rules were written for. The defense's reading, a compliant appellant is being strip-mined mid-appeal to score political points. Both readings fit the documents. That's what makes this hard and why it landed on one judge's discretion. Tuesday, Justice Halloran exercised that discretion for the state. By Tuesday night, Sarn's team had filed for an emergency suspension with the High Appellate Chamber. Quick backstory, because this didn't come from nowhere. 3 years ago, Castellan's office opened its valuation probe. 2 years ago, the civil suit. Allegations that Sarn Holdings systematically inflated property values the Bell Harbor Resort, claimed at triple its municipal assessment, the Meridian Tower at double to secure credit terms honest borrowers couldn't get. 18 months ago, trial. No jury. Ardina's commercial courts don't use them. The defense's core argument. The lenders were sophisticated institutions. They did their own diligence. Every loan was repaid. Nobody lost a crown. The court's answer, in February. Fraud that distorts the lending market is fraud even when the lender survives it. Penalty. Disgorgement of advantage plus interest. $510 million. Sarn called it a purge. Castellan called it arithmetic. The appeal began the same week. The surety fight consumed the spring. It posted in April. It looked settled. Then last Tuesday's motions. And now the part everyone missed. The freeze got the headlines. But at 11:34 a.m., yesterday, 2 hours after the turnover order, the advocate's office filed security interest registrations in all 3 provinces where Sarn operates. Think of them as public liens, recorded with the provincial registries in Port Meridian, Callowes, and the Capital District. Here's why that's bigger than the freeze. Those registrations don't just cover existing assets. They establish priority creditor status over anything Sarn Holdings acquires from now on. New property purchased, the lien attaches at closing. Business income received, subject to interception. It's not a wall around what he has. It's a net over everything he will ever have until the judgment is satisfied. And buried in the 3rd registration, future rents and revenues from named properties, including the Meridian Tower's commercial floors. That tower generates roughly 24 million crowns a year in rent. The state isn't trying to take the building, it's rerouting the building's bloodstream. Look at the clock. Court order 9:52. Central bank notifications 10:15. Provincial registrations 11:34. Nobody drafts and files tri-provincial registrations in 2 hours. This package sat finished on a desk, waiting for a signature. The freeze wasn't a reaction, it was a launch. Stay with me, because the expert consensus on this is genuinely surprising.
The experts, former enforcement prosecutor Livia Anders, 16 years in financial crime. Aggressive, rare, and procedurally airtight. I checked for a defect, I didn't find one. Plain language, unusual but legal. Commercial law chair Professor Denise Okonkwo at Capital University, the registration strategy converts a static judgment into a self-executing collection engine. That's the innovation here, not the freeze. Same conclusion from the opposite angle. And the one that made me sit up, Professor Aldrich Feld, who has publicly criticized the underlying fraud verdict as overreach, conceded in Wednesday's column that every mechanism deployed Tuesday rests on established statute. The scale is unprecedented, the tools are not. When a critic of the case endorses the process, that's signal. Former central bank deputy governor Sella Marchetti added the operational context. RSD 9 exists precisely for judgments of this magnitude. Once the ClearNet flag transmits, member banks have no discretion. 4 hours is the outer limit. Most comply in 1. And banking counsel Rufus Adeyemi, who spends his career building asset protection structures for the wealthy, targeting the overnight ladder accounts tells you a practitioner designed this. That's not something you learn from a statute book. Here's what I could not find: a single credentialed enforcement specialist calling the procedure improper. Aggressive, unanimous. Unusual, unanimous. Improper? Nobody. The real dispute isn't whether the state can do this, it's whether it should, against a defendant who posted his surety and hasn't missed a deadline. Legality, settled. Wisdom, wide open. If this breakdown is earning its runtime, hit like. It pushes this to people drowning in headlines. Now, why you should care even though you're not a tycoon? Because nothing in Article 88 says Viktor Sarn. These mechanisms attach to any civil judgment above the statutory thresholds. Ardina's courts entered more than 38,000 six-figure civil judgments last year. Every one of those creditors just watched a masterclass. Run the small version. You own a mid-sized firm, a contract dispute goes wrong, judgment against you, 400,000 crowns. You appeal, you think you'll win. Old world, post surety, keep operating, wait for the ruling. New world, post Sarn, the creditor's lawyer cites Tuesday's precedent, petitions for supplemental freezes, and your operating account locks while your appeal crawls. Your appeal can succeed and your business can still die waiting. That's the precedent risk, not the politics. Who's feeling it right now? Around 1,900 Sarn Holdings employees. Payroll is processing through an unrestricted structure, but vendor payments are jamming. Suppliers in Port Meriden and Callowes report settlement delays of 2 to 3 business days and climbing. The uncomfortable symmetry: if you believe powerful defendants play shell games during appeals, Tuesday looks like the system finally growing teeth. If you believe appellants who comply deserve peace until the ruling, Tuesday looks like the state eating dessert before the verdict. Both instincts are defensible, but if you own assets or run a business, you're inside this blast radius regardless of which instinct you hold, because the template is now public, documented, and repeatable by any creditor with a big enough judgment. What informed operators are doing? Observation, not advice. Reviewing which accounts sit inside RSD 9's reach, asking their accountants hard questions about overnight ladder exposure, and reading their insurance policies for a clause almost nobody checks: whether coverage extends to enforcement costs during appeal. Talk to licensed professionals, but know the terrain changed Tuesday. And Sarn himself? He made it worse. Wednesday afternoon press conference, gold curtains, full theater. They are confiscating my life's work before the judges have even spoken. This is expropriation with paperwork. Within hours, fundraising messages to his political mailing list, viral clips, the word expropriation trending nationally by dinner. His lawyers, meanwhile, went technical, smarter play. Emergency motion to the High Appellate Chamber, arguing Ardenian precedent requires demonstrated imminent dissipation before mid-appeal seizure, and the advocate showed pattern, not imminence. Then, Wednesday night, their strongest card, a sworn disclosure claiming 450 million crowns in liquid reserves, available if the appeal fails. The argument writes itself. Why strangle operating accounts when the defendant is demonstrably solvent? Castellan's reply, filed before midnight: those reserves sit inside discretionary trusts the judgment can't directly reach, which, her office notes, is exactly the architecture the dissipation rules were written to counter. every filing sharper than the last. Nobody is cooling down. What happens next? Monday, the High Appellate Chamber hears the emergency suspension motion. Wednesday after, ruling deadline. Suspension granted, the freeze lifts and the appeal proceeds on the old rules. Suspension denied, the freeze holds for the 8 to 14 months the appeal is projected to take, and the siege becomes the story of the year. Also on the calendar, the 15th, when Sarn Holdings Political Committee files its quarterly finance disclosure, legally separate from the company, politically inseparable from it. Still unknown whether Sarn Holdings seeks emergency credit to bridge operations, and which bank would dare extend it with a ClearNet flag active, and whether more accounts drop. Yesterday's filing listed the accounts under freeze, but references additional relationships under review. The advocate holds subpoena power over every banking relationship in the group. This may not be the last Wednesday like this. Where we stand? 200 million crowns dark since yesterday morning, a surety posted and now surrounded, a collection engine running that doesn't sleep, doesn't expire, and attaches to money Sarn hasn't even earned yet. Surface story, the state versus a tycoon. Real story, a stress test of whether civil enforcement can hold against a defendant with the resources to contest every comma, and what the winning playbook looks like now that everyone's seen it. Monday's hearing decides the freeze, but the registrations, the priority status, the revenue nets, those survive either way. That's the part to understand. They didn't freeze his money. They built a machine, and the machine is now precedent. I'll break down Monday's transcripts when they drop, and the Chamber's ruling on Wednesday. Whatever side of this you're on, the mechanics matter more than the man. Subscribe for the full picture, not just the headlines. Talk soon.